And next up, we've got an evaluation of the New South Wales Domestic Violence Electronic Monitoring Service.
Hi everyone, I might just grab some water if that's all right. I'm just coming back from losing my voice, and so apologies if I'm a bit croaky. Okay, so thank you everyone for coming and for that superhuman effort, presenting, an economic evaluation and an outcome evaluation and all of the policy context. I am in the fortunate position of just presenting the outcome evaluation for one that we've done today, and so I will get through that. Our electronic monitoring program differs slightly from the one that we just saw. Specifically, this is electronic monitoring that was applied to DV offenders who were released on parole in New South Wales. Specifically, we'll look at the Domestic Violence Electronic Monitoring Program, or DVAM. I thought stacking two electronic monitoring presentations together right at the end of a conference was a little harsh, and so I thought I would start by just sharing a really fun fact that I learned about electronic monitoring while doing all of this work. So my fun fact is that electronic monitoring was actually invented by a Spider-Man supervillain called Kingpin, who was a crime lord that sort of lorded over the city. This is a comic that came out in the late 70s. And as we can see here, Kingpin specifically attaches an electronic monitoring bracelet to Spider-Man's wrist so he can follow him all over the city and track his movements. There was a judge called Judge Jack Love from New Mexico who saw this and immediately started up a company to launch electronic monitoring devices in the US, and the rest is history. So that's my fun fact. Hopefully you found it as fun as I did. My presentation is broadly just structured in these four parts. First, I'll give just an overview of DV policy context in New South Wales and a brief summary of electronic monitoring in past research. Next, I'll get into the DVAM program, how it operated, for who and when. After this, I'll discuss the evaluation method we used, and then why, and we'll get into some policy results and implications. So, starting with that quick policy background on DV offending in Australia. So, we know from national surveys that DV is highly prevalent in Australia. More than a quarter of all Australian women experienced violence from an intimate partner since the age of 16. While it's difficult to sort of properly quantify the effects of this, it's been estimated that the economic cost of this violence against women and their children could be as high as $22 billion annually. Against this backdrop, trends in domestic violence, both self-reported and that reported to police, have remained relatively stable for more than a decade. This is sort of seen here in sort of rates of DV assault in New South Wales, which have remained pretty stable since 2007. So something that's kind of just inherent in these stable trends is that domestic violence is this really difficult policy problem to sort of tackle. And there are very few sort of policies or procedures that are known to sort of reliably reduce rates of domestic violence in practice. So here I pulled out, and I'm sorry for the non-statsy in the room, I've pulled out a forest plot of the largest systematic review of electronic monitoring and recidivism, just to kind of show the general research results about what people are finding with this. Just quickly, for those who aren't familiar, effects are plotted as odds ratios, where here 1 with that dotted line represents no impact of electronic monitoring on recidivism, and these bars around each dot represent 95% confidence intervals. So to see a statistically significant impact of an electronic monitoring program, we would expect those bars to be on the left side of that dotted line and to sort of not cross it to be statistically significant. So the first thing to notice here is all of these international studies have shown really mixed results of electronic monitoring programs. But in reviewing the research, like the individual papers, it becomes pretty clear that the different jurisdictions are implementing electronic monitoring really differently, and the results of these studies might not actually be that comparable. So, for example, this study by the Tennessee Board of Probation examines the effectiveness of electronic monitoring of sex offenders placed on parole in the US. But then we have this other study down here by Roy and Barton, where the authors compare the relative effectiveness of electronic monitoring with a day reporting program for drunk drivers to try and reduce their reoffending of drunk driving. So it's not obvious that we would expect that electronic monitoring would work similarly or equally as well for both of these groups. But despite this, the authors of the systematic review find that on average, electronic monitoring programs often show a positive, though not statistically significant effect of monitoring on reoffending outcomes. So, well, the results of all of these international studies, they're not really that informative for sort of our policy environment for DVAM. They do point to the really specific need for context-specific research when considering how and when electronic monitoring should be used for offenders. Luckily, there's a small and growing body of Australian research on electronic monitoring in Australia, which is starting to show some promising results. So we saw some of these just before in the last presentation. I've got another 2 studies that I'm just going to go through very quickly. So the first is a very similar program to the one discussed in South Australia, except it was delivered as a pilot to DV offenders who were being monitored on bail. And electronic monitoring in this case was associated with higher rates of technical breaching of bail conditions. But on average, the authors find that rates of offending and domestic violence in the period that they were monitored was significantly reduced. So in this case, offending was about half that of the group that were not electronically monitored. The second study that I'm going to just bring some attention to is by Williams and Weatherburn. So just here, the study follows general offenders, so not DV offenders, as we're looking at. And the one thing to point out here is that the same as that previous study, they're also finding these large reductions in recidivism. And in this case, these reductions in recidivism can sort of last longer than just the supervision period. They actually go quite out into the future. So it's clear that some of these programs are working well. And given this, the natural question to ask next is how the programs work, how are the programs working? So primarily researchers raised 2 general theories as to why these electronic monitoring programs might reduce recidivism. So the first is that wearing an electronic monitoring tag changes an offender's perception about the likelihood that they'll be caught and proceeded against for their reoffending. So this change in perception is thought to act as a deterrent while the device is being worn. And the second is that electronic monitoring may help keep offenders compliant with positive case management frameworks. So in this case, with the last study we've just seen, there are a variety in place that, sort of additional assistance support programs that are in place to sort of like target the sort of causes of offending. So it's thought under this second mechanism that electronic monitoring might help offenders stay compliant with these programs to actually address the cause of their offending. And if this is the case, then these electronic monitoring programs can have these longer term impacts beyond just that surveillance period, as we kind of see in that Williams and Weatherburn study. So the DVAM program, we'll get into that just now. The DVAM program is this multi-agency effort that targets these high-risk DV offenders who are released from prison to parole. All of these offenders have active apprehended domestic violence orders, or ADVOs. So for those that don't know, ADVOs are civil orders that are granted by the local court, and they compel a defendant to comply with a set of conditions designed to protect a domestic violence victim from experiencing further violence. So by electronically monitoring offenders, the program aims to improve compliance with ADVOs, but also to reduce offending. So the program primarily works by mapping these exclusion zones that are reflective of location restrictions listed in ADVOs. So in this example to the left here, the green circle represents the restriction listed in an ADVO, and then extending this, the program creates this buffer zone around the area marked in blue. So for a little example of what this might be, here I've included a little house. We can think of this as maybe the address of a victim or a person in need of protection. So once restricted zones are mapped, the proximity of offenders to these areas is consistently tracked. And if an offender enters a buffer zone, they'll receive a call from the electronic monitoring group and they're told to leave the area. So if they immediately leave, there may be no further action. But if they continue into the zone or they ignore the direction, the victims are also alerted to the offender's presence in this zone, so they can sort of take protective actions and sort of leave if need be. If offenders sort of continue into the zone and ignore instruction, the New South Wales Police are alerted to the matter and they can take action against the offender. So there's a few sort of very beneficial frameworks at play here that make this quite effective. So one is that if an offender is found to be in this zone, then it's technically a breach of their parole order and they can be returned to custody. And another one is that these electronic monitoring systems also provide very strong evidence for police as to the breach of the conditions for parole. In addition to all of these actions, DVAM aims to work with victims to produce victim safety action plans and to connect victims with appropriate services. And then some victims can also opt to carry their own device to allow this sort of bilateral monitoring to allow some sort of improved safety while they're not in their home. So the DVAM program's broadly available to people who met these 7 conditions. These include 4 around the legal status, offending history, and demographics of an offender. So the first is that offenders have to be on a parole or an intensive corrections order for a DV offence, though in practice everyone in our study was on a parole order. Offenders also have to have a history of domestic violence and to have a medium to high risk of reoffending. And finally, they can't have a serious cognitive impairment that might influence their understanding or compliance with the program. The next condition is about the sort of ADVOs that they have. So offenders must have an ADVO that prevents contact with the victim, that has these sort of location-based restrictions to allow for monitoring against, and they also have to have at least one person in need of protection listed on an order that is not a child. And then lastly, there's just these 2 quick conditions that determine the suitability for the program. So the first is that offenders have to live with some sort of serviceable range for the devices. So there are some areas where these things just can't work and they can't live there. And the other one is that there has to be enough distance between an offender and a victim's address to make monitoring feasible. So they can't be neighbours. But in practice, these boundaries that they put around people can be even a kilometre. So this is doesn't actually restrict many people in practice. So applying all of these conditions, we find quite a similar group of people were placed on the program, which isn't too surprising. So almost all program participants were male, around half were Aboriginal people. Their average age was about 36 years old at the start of monitoring, and they all kind of lived near a city. Offenders placed on the program all had significant criminal histories, often for violent offending, and around half had served multiple prison sentences in the prior 5 years. Almost all offenders had a medium-high or a high risk of reoffending. So we followed 226 program participants who began the program between July 2017 and November 2021. Just here, I've plotted the number of devices in use in this period by the type of device. The program had this notional limit of 60 devices to be used at a time, but in practice, this was exceeded towards March of 2020. The number of participants was pretty low until the program ramped up in mid-2018. And from here, the number of devices grew slowly before dropping to about half the capacity in the wake of COVID. So we can also look at sort of the length of monitoring that people had. So here I plotted the average length of time that offenders were monitored across these 4 categories. So around half of all the participants were monitored for less than 4 months, and most were monitored for less than 6 months. So it's important to note here that this isn't like the intended length of monitoring when people are released, but actually the actual length of monitoring that occurred. So if an offender sort of reoffends and gets returned to custody, often the device comes off. So the people who were monitored for like very short periods of time here are probably the people who reoffended relatively quickly. The ones who were on the lower end or on the higher end are the ones who sort of didn't reoffend at all. We can also look at sort of the program data to get a sense of like how effective it was looking in practice while they were running it. So the program data suggests that about 54% of the participants successfully completed the program. In this case, that means that they pretty much finished their parole order without a revocation. Around 39% had their order revoked, and this is something people are usually interested in with these programs, but around 5% forcibly removed their own tag, leading to a revocation. In practice, all of these people were returned to custody pretty shortly after this happened. So while these results are promising, they don't actually tell us much about the effectiveness of the program, because we don't really know how these people would have fared if they weren't electronically monitored. So that brings us through to the method. And I apologise to the non-statsy people among us, but I'm going to start talking about some data. So primarily, our approach relied on linking a large amount of data. This was a little bit painstaking. We do this in order to find a group of parolees who were eligible for the program but who didn't receive electronic monitoring. So we sourced and linked these 6 novel data sets. They include information on court appearances and prison from Boxar's reoffending database, details of all active ADVOs in New South Wales from Boxar's AVO database, the DVAM program data from Community Corrections, general electronic monitoring data from the Electronic Monitoring Group, an extract of all people serving community corrections sentences from Corrective Services New South Wales. And then to help make sure this was all linked properly and validated properly, we pulled out a bunch of statistical linkage keys from the police COPS database, which allowed us to sort of like test the validity of the linkage and to make sure everything had come together properly. So by doing this, we were able to observe full custodial and offending records and electronic monitoring histories for sort of all people who were placed on a community corrections order between 2017 and 2021. And so we use this to identify our 226 parolees placed on the DVAM program between July 2017 and November 21, and 768 eligible parolees who were released from prison but not placed on the DVAM program or general electronic monitoring in this same period. Once we've got this sort of comparator group that we can sort of work with for the evaluation, we faced these 4 primary evaluation concerns, and they guided our choice of method. So the first has to do with how comparable that group that I just spoke about actually are with the people who were placed on electronic monitoring. So what we found is that the DVAM program actually prioritizes people who are at a high risk of reoffending for the program. So while a lot of the people in the comparator group were eligible for the program, they on average have a lower risk of reoffending than those who actually received it. So the issue with this is if we don't sort of correct for this or make adjustments, we might risk underestimating the effect of the program. So to get around this, we employ a matching method known as entropy balancing. For those in the know, this is akin to a one-to-many matching model with replacement. So it allows us to really utilize a lot of the data that we have available to us. In sort of our validity checks in the matching, we found that it was all successful and that the groups were much more comparable after the matching model was applied. So the second issue we faced is, and you may have noticed this before, the COVID period, the lockdowns occur in our study period. And this is an issue because they can sort of significantly influence the offending environment and the opportunity to offend in the period that we're looking at. So to mitigate this concern, we take 3 approaches. Firstly, we match on the month of release to make sure that both groups are sort of equally affected by the lockdown periods, or they're equally subject to the same offending environment. Secondly, we included a variety of different controls in our modelling to try and sort of tease out if there was any COVID-specific effects of this. And then thirdly, we sort of applied a bunch of robustness checks to the modelling to make sure that none of these modelling decisions were driving our results. The third thing we did is we really want to know about offending outside the supervision period, not just in the period that they were actively monitored, because there's this evidence that these programs can have these longer lasting effects. And we also have to be sort of cognizant that this is a really high risk group of offenders and they're very likely to return to custody. And we don't want to sort of conflate the incapacitation effects of returning to custody with sort of the effectiveness of the program. So to get around the first of these issues, we look at reoffending within a full year, not just within those shorter supervision periods. And to get around the second of these issues, we only consider free time within that year. So that's time where people were not actively held in custody. Lastly, and this is just a nice to have, we would have liked to estimate a causal effect of this program to really sort of like lock down the effect of the program with sort of nicer evaluation methods, but because we didn't really have any experimental variation and sort of access to the program or anything, we weren't able to do this. So everything we've done is just sort of an associative effect of the program on recidivism. So finally, we can just get to some results. We're nearly through all the statistics, I promise. So for those that didn't follow me through that short journey, what we did, we took this group of 226 parolees who were placed on the DVAM program, and we have this matched group of similar looking eligible parolees who didn't participate in the program. And then we just compare their reoffending outcomes. So here we find that DVAM reduced any reoffence within a year of free time. So the thing to note here first is that both of these groups really are very high-risk offenders, which is reflected in their rates of reoffending. So what we can see here is for that matched comparator group, so those not placed on the program, we find that they have about a 74% recidivism rate within a year. For those who were placed on the program, it drops down to about 67%, which is a 7.1 percentage point drop, or sort of marginal difference-wise is about a 9.6% reduction in any offending associated with the program. We also look at DV reoffending. In this context, DV reoffending doesn't include ADVO breaches. So this is really the more serious DV offending that we can record in our data. We find that the matched comparator group had about 32% recidivism rate for DV reoffending, and those placed on the program, this was reduced to about 21%, which is a very large 33% reduction in domestic violence. We also look at the ADVO breach reoffences, so as with those other types of reoffending, we find that there is quite a large decrease in ADVO breaching within a year of free time after being placed on the program. And we also look at rates of return to custody, which in this context, as with the last presentation, it's very important for sort of the economic outcomes in this space. And we find that while re-entry into custody was reduced, so it goes down from about 60% to about 53%, we don't find that this is a statistically significant effect at sort of more conventional levels of statistical significance. So this is statistically significant at about a 10% significance level. So it's moving in the right direction and it's promising, and it could have to do with the sample size that we're looking at. But yeah, we're less sort of certain about that result. So altogether, the DVAM program is definitely producing, results that are going in the right direction. Recidivism is dropping. DV reoffending is dropping, ADVO breaches seem to be dropping. So bringing it all together, we find that DVAM is associated with those reductions in reoffending, ADVO breaching, and return to custody. These results, they extend beyond that average monitoring period, which might suggest that the program doesn't operate solely through the deterrence of sort of being monitored on a device, but it may be interacting with these positive case management frameworks that exist in the New South Wales parole environment. These results are in line with the other Australian research and contribute to that growing body of evidence to suggest that Australian electronic monitoring programs seem to be working quite effectively, and that they're an effective tool for managing domestic violence in this context. And then the next question is, because these things are sort of working well, there are these questions around expansion and sort of what we might do with expansion. So I think it's important to note, like I said, because of these beneficial frameworks in the New South Wales parole environment that may be supporting the effectiveness of the program, you'd want to be pretty careful about extending this sort of a thing outside of these frameworks. So there's some cases like the South Australian study, which sort of work to monitor people on bail. If there aren't these positive case management frameworks in that context, we might not expect that the program's going to be as effective as it is here. Interestingly though, because we were able to find this big group of offenders who didn't receive the program, there is actually scope to just expand this within the existing eligibility criteria. So we were able to find, 768 people who could have gotten the program but didn't, so we could extend it to them. Or otherwise, even within the current eligibility criteria, people on intensive corrections orders could also be eligible for the program. And it doesn't seem that this is really an avenue that has been fully ramped up with the DVAM program yet. So there is a lot of space to expand it still within the current scheme. Thanks everyone. If there's any interest in the work, it's on our website, and I'm happy to discuss if anyone has questions. Thanks.
Questions.
Oh.
Thank you. That was a really great presentation. Really interesting. Sorry to go off topic a bit, but you mentioned one study at the beginning about electronic monitoring of sex offenders released
Yes.
into the community. Do you know much about the literature on that and whether it's generally found to reduce reoffending among sexual offenders, or was that sort of not part of what you looked at? Obviously, it was outside of the scope of your study, but I'm just wondering if you looked at the other literature on this.
Yeah, look, it's definitely outside the scope of my study, but like having looked at some of this literature, there are definitely cases where it's been found to be effective, but it really comes down to how the different jurisdictions are applying it and sort of the average sort of type of offender who is getting it in that jurisdiction. So if you have much higher risk sex offenders, they may respond differently to lower risk sex offenders. And it really just, and it depends on the positive case management frameworks in those areas. So there's evidence of it working and there's evidence of it working less well. And if I was to get in and sort of tease out why one's working better than the other, I'd probably want to spend a bit more time on those studies. But yeah, it's definitely looked at.
Thank you.
No worries.
Hi, thank you. That was a great presentation also. I had a question. You mentioned two things. One, that the study and the design of the study was so consistent that it was hard to see variable features that you could test in terms of understanding what's causing the result that you're having in terms of reducing reoffending. So I just wondered, from the other work that you've done in terms of looking at other programs or anything that you've looked at in the course of doing this study, do you have any sense about what elements you might want to look at in terms of trying to understand what's causing the impact if you were to introduce some variability into the program?
Do you mean if you were to introduce sort of some randomness into people who are getting it to make it more examinable? Or do you mean if we were to look again and try and tease out like how it's working?
Good question. Either. But probably
Okay.
the latter was what I was
so
getting
the first one, I'm always pro, look, if someone wants to run a randomised controlled trial, I'm very happy to help you. Please give me a ring. For the other, we are currently looking at sort of extending this piece of work. The first obvious place to look is, just extend the timelines and look at 2 years and see if these differences still hold. Otherwise, there's always options for a bit more qualitative work, looking at sort of what kind of positive case management frameworks these people are involved with and sort of how they are responding to them. So there's definitely work on the back burner already to sort of tease this apart, but nothing to show for it yet, sorry.
Thanks.
Hi, how are you going?
Good, thank you.
I'm really interested, and I think you've made a valuable point in terms of the length of time, because 1 year is not a significant amount of time in terms of looking at recidivism.
Yeah.
And I'm really interested, you talked about free time specifically, and I'm interested to know, explain to me again what the free time is.
So we kind of adjust the offending window for time that individuals spend in custody.
Yep.
So in this context, you may end up back in custody without reoffending, right? You can, because you're at this high risk level, and the presumption would be that you get returned to custody if you sort of breach these parole conditions and things. There are a lot of people who may not necessarily, well, not a lot, I mean, the rates are very high for reoffending, but there are cases where people will spend, a week in custody and the device may come off, but then they're released back onto parole. And so to sort of account for these differences, we sort of just extend the window that we look at by the amount of time that someone is sort of held in custody. Just so we're looking at like equal amounts of time in the community for people to have that opportunity to offend.
Okay, thanks.
All right. Is that it? Great.
Please join me in thanking Stewart.